We are live.
All right. It's been since we've been working on a redraft of S14 based on the testimony and other things. So why don't you? Do we have this in our file?
Yep.
Draft 2.0.
Correct.
Yes, thank you, Senator Sears. Ben Novogratski for the Office of Legislative Counsel. As Senator Sears said, this is draft 2.0 of a potential amendment to S14. So essentially what this does, given the committee's discussion from the previous hearings, is that this amendment detaches the reporting from the Justice Reinvestment 2 initiatives to really be broader in scope, which would now include justice reinvestment as part of the data collection and report requirements. So in an effort to clarify the broadened scope of this, there's a new section 1, which is a redesignation of the statute that governs the reporting requirements. So previously it's in Title 28, Section 125, which was under the Commissioner of Corrections responsibilities. This has now been moved to Title 3 under the responsibilities of the Secretary of the Agency of Human Services. This was done for a couple reasons. One, there was testimony from the Department of Corrections previously that making the Secretary or the Agency of Human Services sort of the umbrella organization over this would assist in data sharing and collection amongst many of the departments that are under the auspices of the Agency of Human Services. So that includes the Department of Corrections, Department of Mental Health, Department of Health, and DCF. It does not include the Judiciary, the Office of Racial Equity, but since the majority of departments that would be involved in this are part of the Agency of Human Services, it seemed logical to make that redesignation of the statute to be one under the Secretary of Human Services. What you'll also see now is that, so in now Section 2, which creates or amends Section 3, or Title 3, Section 3029. There are two definitions that are created in subsection A. One is of assistance, which this is taken from the Department of Justice's definition that the Attorney General's office referenced. So desistance means the process by which criminality or the individual risk for antisocial conduct declines over the life course of the individual, generally after adolescence. So that definition is what should capture sort of those gray areas that recidivism rates may not capture, which is sort of someone's crime becoming less frequent and less serious as they get older. And then there's the definition of recidivism, which is a cross-reference to the current definition in Title 28.
Can I, before we go on the likelihood of assistance, understanding is that the one crime where you don't see a decline on age unless addressed as domestic violence, and since it's such a large number of people convicted in Vermont for domestic violence, I'm wondering how that all fits in. Maybe we can check with Department of Corrections or whoever, but that's my understanding that.
Okay, yeah, I can't speak to that specifically, but you know, from a drafting perspective, it could be something that might be carved out and enumerated specifically.
Specifically like domestic, if we're going to add this distance, I'll get it right before the end of the year. To add it, I'd like a special carve out to specifically domestic violence to see if that is actually true or not true.
Okay.
Obviously, you can't write that into the bill, but if it's true or not true, I mean, you can't write it into the bill.
You said this is the Department of Justice definition, because I thought I remembered the person, and I wish I could remember who it was that came to speak on desistance, also sort of pointed to the social things that, you know, that might lead to decrease of crime, not just age. I thought there was a sort of broader definition that didn't apply only to age, but also sort of looked at, you know, the other factors that would play, you know, someone has a job or has gone through treatment or is housed, those things would all likely lead to desistance as well.
Right.
Is that captured here? Am I just like not, is my brain just not processing that?
Well, I mean, it's not a, in my research, there are a lot of different versions of desistance, and there's this whole study that the DOJ did about settling on this definition. From my understanding, it's the clause in here, or the individual risk for antisocial conduct. I think that can be an all-encompassing term. Exactly what is antisocial conduct? It's a vague term, but it can include, I think, a lot of the concerns that you're referencing, because it's the criminality that declines just not over with the age of the individual, but also, you know, their risk of antisocial conduct. And while they reference generally after adolescence as a point in time, it's general. So, you know, it's sufficiently vague, is I think a nice way to put it.
Perfect.
Yeah.
Thank you.
Of course. Yeah, so now into subsection B, this is really the meat of the report. So it would, like I was saying, the Secretary of Human Services is really the submitter of the report in consultation with DOC, Mental Health, the Department of Public Safety, the Attorney General, DCF, the Chief Superior Judge of the Superior Court, the Executive Director of the Office of Racial Equity, and the Parole Board Director to coordinate and submit a report to the various standing committees and also the Division of Racial Justice Statistics on the effects of the state's criminal justice related investments and expenditures on crime and violence in Vermont since the last report was submitted pursuant to the section. So that gives a point in time that they're not just constantly doing a 5-year, 10-year, 15-year look back. It's just any changes in the data collected from year to year, report to report. And so the report now must explain outcomes of these related investments and expenditures, and specifically any correlation between the funded initiatives and any increase or decrease in related crime and violence, and specifically including data and outcome indicators related to recidivism rates, evidence of desistance, bail rates, including detainees held without bail, held with bail and associated monetary amounts, and bailees who post bail and are released, violations of conditions release, probation, parole, and furlough, including whether the violations contain an element of violence and whether the violations are technical, civil, or criminal in nature, whether new offenses committed by former and current supervisees of the Department of Corrections, including whether or not they contain an element of violence or if they're civil or criminal in nature, the status of individuals released from incarceration, including housing and job placement data, the outcomes for individuals served by Justice Reinvestment 2 and related initiatives, including outcome indicators related to. And these were the old provisions. So now starting at the top of page 4 that were in section 125, they've been amended a little bit, but relating to outcome indicators for funding for domestic violence intervention programming in DOC, funding for offender transitional housing capacity, funding for the OMS system, funding for community-based mental health and substance use services for individuals under DOC supervision. And then this is a change that was made from the current law where funding for agencies, departments, municipalities, programs, and services employing restorative justice principles, including community justice centers. This was done with the intention that the Attorney General and the BARGE programs both said in the report that they didn't receive Justice Reinvestment 2 funding. So this broadens it to not necessarily include their programs, but it could if that funding changed. But it's really just about the agencies, the departments, some towns that administer these programs, and then nonprofits that do as well. And then any funding and description of general fund expenditures related to JR initiatives.
This might be a good place to put in. We were discussing an appropriation yesterday, justice reinvestment. And to ensure that justice reinvestment is funded properly, we should insist that at least we did this justice reinvestment. 2 was in 2021, was it? 2020? 2019. The out-of-state bed number for 2019 should be the basis of what you use to determine where. Oh my goodness, state employees, Dave, oh my goodness gracious, look at this. Terry. Yeah.
You call, we deliver. The campaign
I
gets
do
nothing.
appreciate, my goodness. These are from Rutland?
Special delivery.
Rutland.
What about Senator just?
Terry didn't make them, I made them.
Wow, Terry, you
Yeah.
made them.
The way I made them, at Jones.
Today is an exciting day.
Thank you. Sorry for the interruption.
Well, thank you.
This is Vince's call center, I apologize.
Yeah.
Well, yes, we can pass these along then.
What do they want us to vote on?
I don't think anything, they promised me a donut.
They heard you on the live stream talking about donuts.
Yeah, I think so. I'm sorry for the, again, we're, please pass it
More sugar
around.
than I can manage.
No.
I'm gonna do this on camera.
Save it for the break.
Pretty much.
Yeah, they are, I'm not sure I want the Guy Fieri still. Anyhow, might be a good place to put in the something, and Stephanie Barrett at Joint Fiscal can help you with it. Something to the effect that the 2019 average number of offenders out of state would be the base year to determine justice reinvestment funding. So in other words, I don't know what the number was in 2019, but if it was 200 and it's 100 today, then we continue to use that 2019, not this year's, where justice reinvestment has lowered the numbers. Because eventually you're gonna get to, 25 people out of state. And then the next year you go up to 30 and they'd say, well, there's no justice reinvestment money because we didn't save any.
So basically just to use the 2019 base level funding as the reference point, I guess,
Yeah.
for years
Yeah,
going
and
forward.
Stephanie can help you with the language, but I'd say 2019, the average number of offenders out of state, whatever, that year would be the reference number. And I believe it's somewhere around 200.
So the average number of offenders, not necessarily the average amount of savings from that year?
Well, that savings would be dependent upon whatever the contract is. So if the contract is for 30,000 a year, then you take 100 people out, then it's 100 times 3, 30,000.
Okay, yeah, I'll work with Stephanie on putting that together.
Yes.
I thought I remember, and I see Isaac in the room, so this may actually be a question for him, that DOC testified that they contract actually for 3 more than are actually out of state.
Yeah.
So I wonder if the language should be tied to the contract in 2019 rather than the number of people out of state in 2019.
Well, but the number out of state is what we used to determine that there was savings.
Right, but yeah.
I know they're a little bit. It gets a
You
little.
identify
It gets
yourself
less.
for the record.
Oh, yes, Isaac Dano, Policy Director for the Department of Corrections. I would want to check the exact numbers with our financial office. I think part of the complexity is there is a contracted amount and a budgeted amount, and those two numbers are different. The contracted amount, as I believe the Commissioner gave testimony on earlier, is about kind of that release valve if a facility goes offline. If for a natural disaster, there's ability to sort of add people to that out-of-state facility if needed in an emergency situation. And then there's the budgeted amount that DOC budgets, and usually I believe that's around 160 individuals. I'd have to check on the contract amount. And then there's the number of folks who are actually housed out of state. And that changes a little bit here and there, but currently I believe is about between 110, 125 individuals.
Okay,
And so the difference between the budgeted amount and the number of individuals who are currently out of state, the actuals, that is the source of the out of state.
well, yeah, and I'm just wanting to make sure we tie this to the right thing. So it sounds like it would be the budgeted amount, not the contracted amount. Because that's how we get if we tie it to the amount that we're actually out of state, it's gonna be lower. So let me use real numbers. If we had 200 people out of state in 2019, but we had budgeted for 300, that 100 difference is actually what we're looking for. And if we tie it to the 200, then we're gonna am I making sense?
You are, but if I may, out of state bed savings is complicated. And really, because it's not even, I mean, I would venture to say that it's not even, the number that we're looking at isn't the contracted amount, isn't the actual budgeted amount, it's the amount of money that was actually returned to the state because it wasn't spent probably from the budgeted amount. And that is the amount of money that is being sourced from to fund these justice reinvestment initiatives, is that savings. So the difference between probably what was budgeted and what was actually spent. And then that's why justice reinvestment over the summer has the authority, or justice oversight has the authority to reapprove money that was already appropriated through the budget to fund these various initiatives. So there's an extra layer there and admittedly it's confusing.
Yeah, I agree that we should tie it to 2019 numbers. I just want to make sure we're tying it to the right numbers.
And I'm happy to work with our financial lead and get you those exact numbers so we can get a little more clarity on that. But for background, this year, the out-of-state bed savings was 1.986 million. Year before that, it was 777,000. But usually in the past, it's been about 300,000. So you can see it kind of fluctuates pretty widely depending on the number of folks who are actually housed out of state. But as those numbers go down, those savings have increased. But we do sort of hit a contract floor at some point where there is sort of a minimum, I believe, with the contract.
The reason this is absolutely necessary to have is in 2008, we started the Justice Reinvestment One. We were at 750 people out of state at the time we started that. And you see where we are today, but we never, the Great Recession hit, all kinds of excuses, legislature, administrations are both involved. We didn't properly fund community reentry programs. The justice reinvestment, we stopped reinvesting to the level that we should have been. And I don't want to do that mistake again. That's really the reason for putting something in. What it is or how we do it. But if you can think about 750, had we done that, the amount of money we'd be reinvesting into community-based programming would be huge today, but we didn't do it.
And the one thing that I would caution for the committee, and again, working with Stephanie, and once we can collaborate on tweaking the language, is we need to be careful about committing future legislatures to a budget amount.
Well, they can always write notwithstanding. We're actually not a budget amount. Hopefully we're talking about numbers of offenders out of state and using the base year 2019 rather than last year.
Okay.
That's all. We're not talking about the dollars committed.
Okay.
Just a formula to determine what should be part of justice reinvestment. And then the future legislature can always say notwithstanding. Just like we did for years.
Okay, well, that's helpful, and I'll work with Stephanie on crafting that. No more questions on the justice reinvestment funding language. What's now new subsection C is unchanged other than a title heading. Subsection D is data elements and availability. So This just says that anything that was collected pursuant to subsection B must include data elements showing race, gender, age, income disparities, if available. So that's not basically providing a mandate for information that doesn't exist. It gives the out in that case. But that will be revisited later on in the bill as well. Or in this section, because the report required also must explain any obstacles or impediments to the availability and collectability of the data required. So that would, the intent behind that provision is to have the report include commentary, essentially, if there's available data that report requires, or unavailable data that the report requires, and whether or not there's any issues in collecting data that may be available as well. Either sharing between agencies, between departments, things like that. And that was informed by some of the testimony from the Office of Racial Equity about some of the obstacles that they've encountered. And with that in mind, subsection E and F try to emphasize that data sharing is paramount in this, where, notwithstanding anything to the contrary, all state and local agencies and departments that possess the data necessary to compile the report shall, upon request of the Secretary of Human Services, share the information. And the obligation to disclose shall supersede any other legal obligation with respect to the data required. And any entity shall not decline to disclose the data based on any purported legal obligation. So that's just real boots and suspenders language emphasizing you gotta share it. And then the confidentiality section says that everything that's transmitted to the Secretary of Human Services are exempt from public inspection and copying under the Public Records Act and shall be confidential to the extent required by law unless and until the data or records are published in the report. Anything that's transmitted, the original custodial agency shall remain the custodian of that information. And any requests that are for public records that are sent to the Secretary must refer them to the proper custodian. And then that really should do it as far as the confidentiality concerns. And then the bill still goes into effect July 1st, and there is a title change to the bill. So it would now read an act relating to a report on criminal justice related investments and outcomes.
I have one thing to add. And I had a conversation with people at the Justice Center. And they were talking about clearance rates of crimes. And I note that there's been a number of emails regarding Judge Barrett's confirmation that deal with clearance rates. And according to the Justice Center nationally, of every 100 violent crimes, only 46 are reported. And of the 46 that are reported, 19 are solved. And their theory is that you are more likely to be deterred from committing a crime if the likelihood of getting caught is high. If the likelihood of getting caught is low, then the deterrence isn't there. They're not looking at, you mentioned during an earlier discussion on S4, or maybe it's not the $100,000 fine. I'm not thinking about a $100,000 fine or whatever the fine is. But I think it makes sense that people would be looking at what is the likelihood of getting caught. So I wonder if we could get information on clearance rates on violent crimes in Vermont. We obviously can't tell how many are not reported because nobody would know that. But of those that are reported, what number are solved within a period of time to conviction, which would take into account your backlogs. What cases are backlogged? How many cases are backlogged in the criminal justice system, so that they're not, the longer it takes. So I don't know if that's clear in terms of
Yeah, so I think it would be clearance rates of reported violent crimes. I might talk to CSG about defining the term clearance and adding it to the definition section. But, you know, basically it would be the amount of reported crimes that are adjudicated, investigated, solved, or otherwise closed from citation.
Well, closed from all the way through the system, so that there's been a, you know, we're looking at a backlog. You reported having to go to court for a 2016 case
2016, I still have a 2017 case.
and a 2017 case pending. That to me is the likelihood of getting caught and then having a 5-year or 6-year period between actual trial.
So
I
basically,
assume they're trials that you have to testify.
so basically the life of a case from the offense being committed itself to the finality of the case.
Yeah.
Okay.
Picture yourself as the victim of the crime that's 2016.
Yeah, I can work that in and I'll talk to CSG about getting the clearance language correct.
This is not related to that, this is something different, but, you know, one of the things we've heard a lot is the impact of substances within the criminal justice system, and I would love to see some more specific language, and maybe it doesn't exist, but particularly around technical violations and whether they're related to mandatory treatment or a drug test violation, just getting a sense of how many people are going back for substance use related reasons, as well as really looking at the effects of and the cost of the criminal justice related investments and expenditures for arrests related to possession and personal use. I think that there's a space here to really, and what I'm thinking of is the barriers to employment, housing, educational opportunities, overdose rates, and other sort of social and economic impacts, but just really starting to look at like what's happening when we arrest for substance uses as opposed to making community investments.
I think that can be worked in, especially when it comes to sort of the nature of technical violations being drug related, drug possession, something like that. The one thing that I've learned through this process, through talking to the Office of Racial Equity, is making sure that we have that the data can be quantified in a way to be reportable. And I can't speak to this, but I would just say, as far as, you know, the harms associated with arrest and criminal legal system involvement, I think we need to really be specific as far as what data elements we're looking for and whether or not they can be quantified. So I might, that's something that in drafting this version of the amendment, I really tried to make an effort on to make sure that the entities that we're asking the data to be received from can actually produce the data, and if there are obstacles, why not?
This might be a good time to hear from some of the people that are on the line or anybody in the room that wants to comment. We've got about 10 minutes left on this. If you can take your screen down, whatever you call it. And is there anybody in the room who'd like to comment at this point on anything you've heard so far? Anybody? Yes.
Hello. Thank you for taking my testimony today. I'm Jay Green. I use they, them pronouns. I'm the policy and research analyst for the Office of Racial Equity. I first wanted to say that I agree with Senator Wachowski's comments about wanting to use this as an opportunity to measure whether people with substance use disorder are being additionally criminalized by being sent back as a parole violation when they have in fact relapsed due to their mental health condition. The thing that I would like to raise for the committee today is I was curious about the language and potentially adding a definition for the elements of violence on, I believe it's page 3, line 17, section E. This is the list of, after section 2, the report shall explain the outcomes of the state's criminal justice related investments and expenditures, and then some section E including whether the offenses contain an element of violence and whether the offenses are criminal or civil in nature. So I was curious about what an element of violence means there, because there are sometimes racial disparities in what people are charged with. So if you're going off of measurements, if you're using what people are charged with to measure whether there was a element of violence that could be different from whether their behavior was actually violent in nature. So for example, if you said that anyone who carried a weapon to during the alleged commission of a crime, if you said that just carrying a weapon was an element of violence, that would lead to different rates of that measurement than if you included whether someone actually used that weapon during the commission of a crime. So that, yeah, I think that could maybe be narrowed down and be a little bit more specific about whether you're looking at how are you measuring it? Are you measuring it based on what people are charged with when they, or are you measuring it based on more specific behaviors that someone may or may not have done during the
Committed invites the word conviction.
That have been convicted.
Well, yeah, committed, is it convicted or charged? That's the question I think you're asking, right?
Yes and
You can be
no.
charged with aggravated assault. Let me give you a better one. You can be charged with DUI, but it can be pled down, or the state attorney can offer you careless and negligent driving. Happens all the time. So is it a charge, or is it what you're convicted of? Is it the careless or negligent, or is it DUI? And what are we counting here? That, I think that's the question.
Yeah, I think that is a more, I'm not, I don't have a legal background.
Well, neither do I, but
background,
I
so
play one on
I think
TV.
that, I think that makes sense.
I think that's the question.
Yeah, and I would argue that there's also, or suggest that there's another element that I think my colleague is suggesting, is that, you know, you could say, is it charged with a crime involving an element of violence, convicted, or you could even argue that as is, it could be even reviewing, say, the affidavits underlying the charges and seeing whether or not, you know, the facts as memorialized in that affidavit contain an element of violence, and that can be separate and apart from the charge that was actually brought. I think there's a practicality aspect also in reviewing this type of data to see, you know, is it really practical for people to go through affidavits one by one, or do you want to just review charges?
I think it's either charged, it's either got to be new offenses, and you take out committed, and it's either charged or convicted. One or the other, I don't think.
Perhaps the Executive Director of Racial Equity, Susanna Davis,
Yeah, somebody
could speak to this a little bit further, because I feel like I'm reaching the edge of my competency a little bit. But I do want to point out that there are racial inequities in what people are charged with and in the plea deals that people are offered. But perhaps my supervisor, Executive Director of Racial Equity, could speak to that.
Good morning. For the record, Susanna Davis, Racial Equity Director for the state. I apologize for not being there in person. Right before you got started, we were still in lockdown, so I figured I'd just stay here. The question at hand, I want to hear it again because I want to make sure that I'm speaking directly to it. But as far as I understand, what we're currently discussing is the practical and operational and just technical matter of how we're assessing threat of violence and how the charging decisions get pled or not. But if someone could just restate the specific question, then I'm happy to speak to it.
I think the specific,
Oh, no, you go ahead. I'm just.
no, I think the specific question is, would we prefer to have the new offenses committed by former or current supervisees charged instead of committed, new offenses charged? Or is it new offenses convicted of?
Yeah, I mean, you know, again, as Jay was beginning to say, there's a lot of racial disparity in what happens at the charging stage and who even enters the door versus who actually makes it through. So we would be interested to receive data at the biggest portion of the funnel as much as possible. So capturing not just who's actually convicted or who goes through the process, but who's being charged, because I think that's an early entry point that would be useful for us to be able to look at.
So I would change committed to charged.
Okay.
Thank you.
I would suggest that in order to track disparities, we would want to measure both what people are convicted of and what they were charged with, because that would help identify disparities in who is receiving what kind of plea agreements. Feel free to disagree if I'm off base here.
Well, I don't know.
That certainly makes sense to me, and I think that's one of the pieces that has come up in a couple bills, and that I don't think we do talk about as much as we talk about bias in other areas, but that's sort of like the implicit bias within the judiciary.
And to follow up with this, I think, one of the other conversations that we hear about is, we have all these different criminal justice systems, but we have, all these different counties, different states attorneys, and there can be significant geographic differences in one county versus another.
And what resources are in the community. So I think if we're talking about, where we need to build resources, it's an important thing to be looking at as well.
But I want to make sure I understand, you're going to have both. So it'll take two separate sections, I think. You want to have both. We have donuts too now.
I think I'm going just for the cookie.
You missed them while they were still warm. Yeah, when Terry brought them in, they were still warm.
Oh, Terry. But we're not going to be able to identify who they are, right?
Well,
In other words, so person A is, going back to my DUI, careless and negligent, person A gets the charge dropped to careless and negligent, person B sticks with the DUI. We don't know why. We won't know who was who. We just know that we may know racial factors and other factors, but what are we gonna learn?
well, with the evidence of desistance language in combination for it, it can be interpreted to say that it should capture all of it, because desistance would be an individual and whether or not they've recommitted and what those charges and convictions may end up being. That being said, we can elaborate a little bit more in the language to really make it clear that these need to be tracked for individual offenders, that are charged with new offenses and then what their ultimate
One of
convictions
the
are.
problems we ran into during the initial cannabis debates, when we went to legalize cannabis possession. And, we continued to hear reports that nobody was incarcerated for simple cannabis possession in the state of Vermont at the time we did. But you did find some people who were, one of the charges they were incarcerated for was cannabis possession, but they also had, stolen cars, et cetera, et cetera. So how do we know when we're compiling all this information, committed and charged? Maybe it's simple, but maybe the state's attorney is less likely to reduce the charges to somebody who's got 10 other charges. Or maybe they're more likely to dismiss those charges because they've got more serious charges.
Mhm.
Will that come out if we're doing convicted of?
Again, I think with the evidence assistance language, it could be, and it should be, but again, I think we could probably make an effort at clarifying it a bit more, but just the level of detail to which, is it tracking individuals specifically?
Yeah, that's what I'm
Right.
confused about now that we're getting into this, that we're tracking individuals who may have been incarcerated previously.
I mean, a simple fix could just be on page 3 on line 6, it says the report shall include data and outcome indicators related to, and then add individual. And then that would apply throughout.
Because it would be important to understand the reason that this person was actually got this was there were 10 crimes charged versus 1 crime charged for the other person. It would look really strange.
Yeah, I think adding that individual language to make it clear that we're essentially tracking each person that's in contact with the criminal justice system for these various data points.
Or the number of charges,
assistance evidence.
so the number of charges brought on the individual and the number of crimes convicted of by the individual.
Yeah, so I think adding that would clarify that these should be for individuals as opposed to sort of an aggregate percentage.
Well, I think is there anybody who'd like to comment on where we're at so far? Is anything else on S14 before we come back to it probably next week? Or we got it scheduled later this week?
Don't believe so.
Well, when we agenda build tomorrow morning, add a day for S14. Nobody with any comments, great. Thank you, Ben. And don't go very far. We're gonna take up S6 next. And we have Christopher Whipple, Deputy Director of the Vermont Criminal Justice. S6 is the accolade custodial interrogation. Thank you, Isaac. Thank you. Thank you, Isaac.
Save it for myself, please.
Chris, are you there? Yep. Okay.
I'm here, Senator Sears.
Yeah, we're, and Ben, maybe you can just outline briefly the section that is proposed to be added to this bill.
Sure, so the section that concerns Vermont Criminal Justice Council would be the creation of a model interrogation policy, which is governed by, it would be section 5 of the bill, which is on page 7 of draft 2.0. And then also in section 4, this is a new section from the last version that was seen that makes grant eligibility contingent on compliance with the interrogation policy. So section 4 and section 5 would be the ones that most likely concern the Vermont Criminal Justice Council.
So that's 2.0.
Yes. I could go back into the details of those.
Yeah, have you seen those, Chris?
I have, Senator Sears, yes. Just looked at them briefly this morning, yes.
I wonder if you or have any comments? And we have Judge Zone, Tucker Jones, and people from the ACLU and Mr. Erb from the Innocence Project and John Campbell, who may want to weigh in on these sections as well. Go ahead, Chris, please.
Absolutely. Well, thank you for the opportunity to discuss this section of the model policy. And it would appear as though, from what I've read in the legislative language, that certainly the section regarding things about grants and the inability of agencies to use grants that would not, if they were not following this policy, certainly sounds like it's a step at making sure that agencies are compliant. Where I have a little bit of concern is that, and when I say concern, I don't mean that that does not equate to opposition. I think that where we look at council policies, there are several that the Criminal Justice Council are responsible for and have been given that authority to create statewide model policies in the past. And we want to make sure that when we are creating policy, that we're given the resources and time to make sure that policy is thoughtful, it's thought all the way through, and that we have the stakeholders provided to actually weigh in on those. So as you can imagine, I'm sure there's been a lot of law enforcement discussion on what interrogation consists of, what is in custody, what is out of custody, and I haven't been here for those testimonies. But what I do think is important is that the clear understanding of not only the mission of the council, but the makeup of the council. So as you know, the legislature created an expanded council, which now consists of 24 people. And typically for a model policy to be developed by the council, what that would look like is discussion of what that policy is, and then the committee or the council putting together a subcommittee of interested stakeholders within that, what that policy reflects, to have thoughtful and spirited discussion and take input from other stakeholders that would be germane to that policy. And then also look at how we would train out to that policy looking forward. The statutory language, I don't think, has changed for the council in that it requires the council to meet quarterly, but the council does meet monthly. Actually, they meet twice monthly, once for contested hearing dates and then the other for just council business. And there is a lot of business on the plate of the Vermont Criminal Justice Council. So any thought process going forward as far as developing this model policy, we would just ask that we are resourced and given the time to do it so that we are successful in producing what the legislature wants us to produce for them.
How much resources do you need?
Well, let's put it this way. We, right now we are looking favorably, at least within the governor's recommended budget. And it's specifically looking at just things where we're in a snapshot of time right now, as far as the curriculum review and fair and impartial policing positions. We don't have a policy director. So, writing policy and policy that affects many stakeholders and then holds them accountable to this policy, which would also have some potential significant impacts within Act 56 if there were violations of this policy, and the council services to an agency that's not adhering to the policy. It all intertwines. So the resources are in the staffing. So for instance, if just getting further on down in the policy where we are required to train to that policy, we have limited amount of trainers here. And as you are well aware, we have a lot of adjunct faculty that come in pro bono and do the instructing here at the academy. The interview section, and specifically where it evolves around juveniles, is handled between the adult interview section and juveniles between about 5 different people from different agencies. So it would be a matter of not only getting our staff, but the adjunct faculty staff on board with what the new policy requirements are, teaching them where they interweave with each of their classrooms, and making sure that that policy is clearly understood. So when I say resources, we don't have clearly the staff to do that. And we want to take on the work and that responsibility to do it. We want to do it successfully and make sure that we have the ability to do it right.
I'm still looking for a number.
A number, hey, I'll give you just an example. A policy director would be great. We're often tasked with
100,000?
writing. Excuse me?
100,000, 50,000? What?
I would say
To have a policy director.
I would put the number more between salary and benefits of somewhere around 150.
Okay.
Can I ask a question that is not related to having a policy director, but
Well,
related
first-
to the process?
I just follow up on that.
Yes.
So a policy director would not be just writing this policy, but all policies. Am I correct?
Correct. Absolutely
And
correct.
Policies and et cetera. It wouldn't be a position just for this bill.
Absolutely, Senator. I mean, right now we're in the review stages again of the current fair and impartial policing policy, which gets reviewed annually for potential changes or not. But that again is a subcommittee work. And with the amount of time that people are donating their time to the council and their service to the council, that those things don't move as quickly as one might expect that they do.
But we're attempting to have a lot of model policies adopted by, so we have uniform policies throughout law enforcement in Vermont, from sheriffs to constables to anybody, state police, local police, so.
Makes great sense.
Tanya,
Yep.
unless it's on this.
Yeah, it's quick. You know, I was just thinking, you know, 150 grand or however much, you know, for a new position. I mean, is that something that should be discussed in an appropriations bill?
It will,
Instead of,
but what I would do is we would add an appropriation to this bill. The appropriations committee could delete section 5 and say, well, take that out, then there wouldn't be any policy. They could say, do it on your own, or they could fund it, or they could say, pass the bill and we'll put it on the list and see where it goes. But we'd have to, if we do this, then my intent would be to put an appropriation section for 150,000 on the bill. Or whatever number, and maybe you want to go back and see what a real number is.
Absolutely.
I must have missed something, but at least in my mind, I'm just feeling like there's a disconnect between just the content of this bill versus creating a new position for creating all these other statewide policies. And I mean, I get it. I understand where they're coming from of creating a new position, and you know, I'd love to hear more about it and support it. But yeah, I'm just feeling like there's a disconnect between the contents and the substance of this versus creating a new position. So, just my thoughts.
Well, explain it in a funny way. In the Senate, we have two committees, and it happens that two members of this committee sit on appropriations. So we're kind of mindful of the fact that, as opposed to the House where you're in one committee. And so we frequently do this.
We created a position like this in a similar setting for OPR last year. It was a bill around mental health, workforce development, and we created a whole OPR position in that. So we do it in the House too.
Appreciate that. Yeah, just my own lack of knowledge.
Well, I guess certain House committees do it.
And it is kind of, I take the testimony to be that this is kind of the straw that breaks the camel's back. They're doing a lot. They feel like they could do this, but it would tip them over into needing more. So why not bring that policy person on and not only take care of the straw that broke the camel's back, but the other straws.
And we do keep asking for model policy, which is, I think, an important thing to have, so that everybody's on the same page.
Well, I'm glad I asked that. Thanks for the clarity.
So Ben,
Yeah, I can add an appropriation, and I'll talk with Deputy Director Burkell just about what the number.
Yeah, well, let's, firm out the number to, not just now, go ahead.
Perfect, thank you. So the model policy meetings and that subgroup that you're talking about, are those stakeholder meetings open to the public, or are those private meetings?
No, absolutely. They're always open to the public. All council meetings are open to the public, as the committee groups are as well.
Awesome, thank you.
Are there any other comments on the redraft section 2.0? Anybody in the room would like to make? Yes.
Julio Thompson, Attorney General's Office, Civil Rights Unit Director. It's just a minor point, but I think that we would recommend that the language about the department's policies reflect the language that's used in existing statute regarding the model fair and impartial policing policy. Section 2366 of Title 20 requires law enforcement agencies to adopt a policy that, quote, includes each component of the council's model policy. So that leaves them the opportunity to add greater protections if they want to go beyond what the council does, but it has to comply with the minimum portion of it. And so they can customize it for their agency. There may be some agencies that don't have a detective, for example, or I know one agency nearby that the only detective is the chief of the department. And so they may want to have things that are tailored to their department, but contain the core requirements of the model policy. The way it's drafted now, it makes it sound like they have to adopt a model policy, and then the council has a model policy. And I think you just want to mirror that. And I think that the same is true with the body-worn camera policy that the council has come out. So we would just want that for consistency.
So it's a minimum standard.
Yeah, you comply with each element. And then again, you can have additional elements. A department could theoretically say, if the statute has the age of 22, a department could change the age and raise it and say, we're not going to use the section for anybody under 25, if that's what the department and the community wants. So we would just, and that language I think has worked for the fair and impartial policing policy that's been, in existence for a number of years. The second comment I have about section 5 is I didn't see it, and it's possible because I'm working on a smaller laptop than I usually have, but I didn't see a deadline by which the council develops the policy.
January 1st, 2025.
Well, I have that they will adopt it, but I don't have when that the agencies, I think, were required to adopt it. But it doesn't say when the council establishes the policy. And maybe it's intended to be the same date, but we would just want clarity on that, because right now we read it as January 25th applies to the agency, but the establishment date of the model policy is specified. So maybe just a minor drafting.
And to answer that, I mean, the way that they would operate in concert, at least the intent behind the language, is that once each agency has to adopt, follow, and enforce the policy established by the Criminal Justice Council, in theory, that is the kind of, for lack of a better term, drop dead date for the council to do it. But practically, they need to do it before, so it could be adopted by the individual agencies by January 1st, 2025. That being said, it can be more clearly delineated if the committee wants a firm deadline for the committee or for the Criminal Justice Council to establish the policy.
Well, if we're giving the money, I think we should have a firm deadline.
I have two questions not related to this. One is about the effective date. I know we've kind of gone back and forth as to whether or not it should be 2023 or 2024. And then my other question is actually about the title. It seems to me that we, with the development of policy to apply to everyone, and different ages, that we've actually moved out of the realm of custodial interrogations of juveniles, and now we're just talking about custodial interrogations. And so I don't know if, I just am not sure if we want the title to change.
I mean, it can change to be, an act relating to interrogation policies in the state or something to that effect.
Well, when did we move out of just juvenile interrogation?
Well, so this model policy in my reading would apply to interrogations broadly,
Yeah.
not juvenile interrogations, which is why it makes me feel like we're actually talking more about interrogation policy as a broader conversation. Like, yes, we've still set the age time, which tied to youthful offender, but the model policy would apply to everyone.
Yes, I missed out, missed a lot of things.
I mean, maybe I'm wrong, but that's just sort of my, like, the scope seems to have expanded to me.
And presumably the model policy would talk about the age limit for 22 and then create a policy for everybody else. Is that what we're getting?
Well, yeah, I mean, that's how I read that language, is that the model policy would be model policy that captures all interrogations.
Yeah.
I don't.
It's a question, I don't feel strongly, just the scope of the bill seems to have expanded to me.
That's an easy change.
Are there any other comments from the audience, either here or out there on the Zoom?
Senator Sears, if you don't mind, I would just concur with that assessment. As I was looking at this as well as an interrogation policy that applied to everyone with a specific carve out and that pertains to juveniles, but one that was a whole policy, and agree with Julio's assessment that along with what we would have, like we do have with the fair and impartial policing policy, is that they have to have all of the essential components of the council policy, which allows then an agency to add additional protections if they would choose to do that.
Thank you. Mr. Erb.
Good morning. For the record, Nathaniel Erb. I have more of a question if the chair will allow. For the section 5, the question I had was the statewide policy doesn't reference the rest of the bill in the ending of the use of deception, and does there need to be language that the model policy will teach towards ending the use of deception and expanding? I think, as I understood in the last committee meeting, was the idea being we're going up to the age 22 or 21 for children at this point, but we want a statewide policy largely trying to expand the policy that the state police has, which just teaches the peace model to all statewide agencies. And does there need to be language in section 5 that says that's the legislative intent, that the policy will teach the use of alternative interrogation methods beyond deception? Or is that just read into bill to be understood that that's what the council is going to develop? I don't have a position in either. It's more of a question as being a bit of an outsider to what the standard practice is with the legislation.
There is no intent section, so if the committee wants to make it clear that the purpose of this statewide model policy is to make sure that the Reed method or any other maybe controversial interrogation methods are not taught, we can write in some intent language to clarify that.
I'm okay with.
Yeah.
So would it, to kind of drill down into the details of what that intent would be, is it?
Current, one way to write it is current Vermont State Police policy would be the minimum model. What we've heard state police policy is.
Is there anything that we want to be explicitly excluded or included in the intent section that they shall, I can reference the Vermont State Police policy.
We could reference that, we could reference the model, the policy, the under 22. But I don't know if that's necessary. I think they come up with a policy that says deception and the read method is acceptable. I mean, I think we would hear about it since they're all public meetings, and I think that would be something that they probably wouldn't do. But if they did, we could certainly act on that.
True.
I mean, so I don't know that it's necessary. I think if we write it in, we run the danger of being overly prescriptive in what the policy should be. So I think maybe leaving it as is and letting the council come up with a policy, and it'll be a public document, so kind of, I think we write the intent, I think we could get into being overly prescriptive. The way I'm feeling right now.
Yeah, I mean, I can see that, and I don't know that the intent needs to necessarily say the council shall implement the VSP policy so much as, I think the question is whether the intent is to end the use of deceptive interrogation practices and come up with a different way of interrogating people. So I think there's a way of zooming out further, or even aligning with the International Police Training Association's findings that this is not a useful tactic. But still leaves a lot of broad space for what is the policy? Like, we don't want that.
Right.
Now you can create what we do want.
And it's fearful of telling somebody to make a policy and then.
And
Yes, Marshall.
from the sideline, Marshall Paul, my concern about if there was a policy that would, if the bill actually prescribed that the policy needed to incorporate the methods that are currently being taught, meaning the peace method, our concern about that would just be that these methods are developing over time, and we don't want to fix something in time. 10 years from now, peace method 2.0 comes out. We don't want to have to come back to the legislature to get special permission to modify that training curriculum just to simply keep up with the times. So it would be our office's suggestion that we don't do anything that actually refers to or incorporates by reference any current training models, just to allow that development in the future.
And that's, I think, sort of what my point was. If instead of saying you must use this, we say you shouldn't use that, it sort of excludes what we're trying to get away from rather and includes any possible alternatives.
I don't really.
Well,
up so far.
We could let that gel for, or are we're not moving to vote this out.
Well, we could, but we need to see 3.0 or 2.1.
Did we come up with a drop dead date on the effective date on this, or?
No.
I was just wondering, they're looking at, the council was looking at possibly getting a policy writer. I just wonder if we just ask Chief
We can
Raquel
give them an effective date of whatever they need.
how much time he would need or anticipates, or?
We can give them a different effective date, make the sections 1 through 3 effective July 1, 20, or January 1, 2024, or July 1, 2023, or October 1st. I agree that July 1, 2024 is a long way. Then the older you get, more time flies, tell you the truth.
The other suggestion I may have is that you could keep it technically all one effective date and then just create a deadline for the council to create that policy and then another deadline for the policy to be adopted. So right now, all that's in there is the adoption deadline of January 1st, 2025. So that's another option as well. So what it would do is that it would go into effect, it would allow the appropriation to be made now for the new position, and then based on whatever the committee's discussion is, we could create other deadlines after that.
Chris, I'm sorry, go ahead.
So my question around that, so if we're working backwards, we're saying all local law enforcement must implement this policy by January something, 2025. Reasonably, how long does it take for a local law enforcement agency to implement a policy? Because I feel like we can work backwards from their deadline to determine the Criminal Justice Council's deadline. And I'm looking at you because maybe you know?
Yeah, I think it depends on what the policy is. I mean, there's no one idea. I mean, the policy could be relatively simple or it could be extremely complex. You know, it could take a few days, it could take several months to develop a policy, but also, you know, developing policy that wasn't in my area, but.
Well, I'm not talking about the development of the policy. I'm talking about the implementation of the policy, because the date we have is for implementation. And if it takes 6 months on average, and I'm picking random numbers to implement the policy, then I would suggest the deadline for creating it is 6 months before the current deadline we have in here. That was what I was trying to get at.
Yeah, Mr. Bicknell
Yeah.
has a comment or question. Go ahead, Mr. Bicknell.
Thank you, Senator Sears. Just when you start talking dates, those things just alert me to make sure that what we want is a successful, comprehensive policy that's easily understood and can be taught out. So currently the PEACE model is taught at the Vermont Police Academy. That is the model that's being used now. And, you know, I'm delighted to hear even the word appropriation being mentioned in this committee as a potential word. But having said that, as you are all well aware, acquiring talent and hiring it are two different strategies that take some time. And I wouldn't want the council to be hamstrung or rushed into trying to meet a deadline that they were not prepared to meet. So typically, as I mentioned earlier, you know, we put committees together with subject matter experts that will have input into these. We would also, as the council, be reaching out to IADLIS, the International Association of Directors of Law Enforcement Standards and Training. We'd be getting best practices nationwide. So those things take time, and you want Vermont's policy to be solid, and you want agencies to be following it. And I don't know that it's critical to rush something that what I'd like to believe is not a horrible practice that's currently happening in Vermont. I understand the rationale for wanting this policy, and the sooner the better. But the January of 2025 date, as I've heard mentioned as the implementation, would, if it was just left without a set date for the council to have a policy by, it gives them the opportunity to actually take all this testimony, have these meetings, and potentially develop a policy if we were resourced and or if we had great input from the stakeholders sooner than that date. But that would give a final date deadline that it would have to be produced by, and that agencies would have to follow it by. But ideally, you would like that clearly before, and then some training coming up to the implementation of that policy. I guess in short, the more time, the better is what I'm saying.
There's two separate times in my mind. One is sections 1 through 3. That's the sections on juveniles. Then there's section 4 on the grant ability that should be, and then there's section 5. So sections 1 through 3 could be July 1, 2020. I'm going to just throw out a date, July 1, 2023. And sections 4 and 5 would be January, whatever, 2025, January 1, 2025. And then we can debate that. So, yes.
So I agree, Chris, with a lot of what you're saying around wanting to not get people stuck or not wanting, you know, allow for this to move faster if possible. My concern, though, with no set deadline for a policy to be completed is that we're gonna hear back in November of 2024 that the policy wasn't ready in time and we can't possibly implement it by January 1st, 2025. And that we're just gonna keep, and I've seen it happen with a couple different things where that's sort of how it unfolds. And so I feel like this is why I'm trying to get a sense of what is a reasonable deadline to have policy done and how long does someone need to implement policy? I'm trying to get out ahead of the, we can't do that because it wasn't ready in time.
I agree. An interim deadline for the council to come out with the policy seems to make sense to me, because I do think, and raise the age is in this category, we're getting sort of set of delays that were conditioned on the pandemic, now they're conditioned on the workforce shortage. And I feel like there's just a general willingness to push up against a deadline and say we can't do it. But if we're putting resources in especially, there shouldn't be any excuse for not being able to. So if you were talking about January 1, 2025, that's the date for it to go into effect, you know, could we give them 6 months before then an interim deadline?
Yeah.
And just for reference too, when I started drafting this policy, I looked back at the other model policies that are in effect, and if I'm recalling correctly, I don't believe that there was an establishment of policy deadline. There was just sort of, once it was adopted, deadline. But from a point in time, I believe that at least with the, I think it was the fair and impartial policing policy, I think the act passed in 2017, and then 2022 was the year that it needed to be adopted. So that's roughly 4.5 years, I believe, 4 years, give or take, depending on the passage of the bill. So I don't know if that's a good discussion point for the committee for this time frame.
Well, I'm gonna suggest that we work back. Yes.
Julio Thompson, Attorney General's Office. So the statute regarding compliance, the fair and impartial policing policy provided that by March 2018, so the policy was enacted in 2017. So it was less than a year between the enactment of the model policy and the requirement to comply with the elements of the policy. That statute is 20 VSA 2366, section A1.
Well, why don't we follow those timelines? Because that would.
It sounds like we're going a different way, but I was going to support Senator Burr's thought that we work backwards from the implementation deadline by
I think
6
that's
months,
what we're doing.
which puts us, which puts us
Just
in
doing
like June 1.
the same months, however many months that they had for the fair and impartial police, they'll get for this.
I was thinking there was 2 days back in the day, if fair and impartial policing was. They came up with, and obviously who will correct me on this, they came up with a date that all agencies had to have fair and impartial policing model policy into the academy. And then there was a second job that date that said if you don't have one, you will abide by this policy that came out of the academy.
Right.
There was a little bit of a gray area there. Yeah. Memory serves me correct. I remember we came up with one. We still had to adopt theirs anyways after the fact, so.
Which we're not asking municipalities to do their own. We're just in this bill saying you've got to use this. So taking out the additional step.
I could add a little clarification on that point if you would like, Mr. Chair.
Yeah, go ahead.
Again, Julio Thompson, Attorney General's Office. So the fair and impartial policing statute was amended to provide that if an agency has its own fair and impartial policing policy, and it fails to comply to have a policy that meets the elements, then as of January 2019, so the following year, by operation of law, the agency is deemed to have adopted the full model policy. Right. So if you have elements that are missing in your department's policy by operation of law in 2019, the following year, that's the corresponding portion of the council's policy is by operation of law your department's policy. So it was a way to make sure that by operational law, that everyone was meeting the minimum requirements. And if there was a provision that was inconsistent with the model policy, then by operational law, that was deemed to be null and void. So that's how it was amended.
Good. So you're right. You're all right.
One blind spot onto another every now and then.
So. Pretty much. Thank you all. We'll come back to this.
So serious, just to clarify, so sections 1 through 3 keep the same effective date. Sections 4 and 5 will mirror the timeline that the fair and impartial policing policy was implemented. And then as far as the new section concerning appropriation, I'm assuming that that should probably be included with the section 1 through 3 effective date.
Yeah. And should we schedule this for next Tuesday? Along with S6, that's something else.
Yeah, I was gonna say an hour for each one of those,
Pardon?
an hour for each one of those next week.
I'd say half an hour. For each. So,
Can I just ask a technical logistical question about effective dates? So if the effective date for section 4 and 5 is January 1st, 2025, does that then mean that they cannot begin working on that until then? Or does it make sense, like you were saying, to have one effective date with these carve out dates for deadlines within it?
Well, I would say that there's nothing to stop them from working on it, but they're not required, like these provisions wouldn't go into effect until a year and a half from now, so to speak. So you could do one effective date with those staggered timelines worked in, or 2 different effective dates, but there would be no obligation and those provisions would not be in effect until that effective date.
So I wonder then if it actually makes more sense, because my understanding of the intent is we want them to get working on this sooner than later, is to have one effective date with the carve outs for the deadlines.
Yeah, and if the committee decided to do it that way, that would be in line with the model in the fair and impartial policing, where they, it was passed in 2017. They had to have the policy implemented by March 1st of 2018, but then there was that sort of gray area that Senator Norris was talking about, where in 19, that if there was no policy, the model policy adopted by the council would become the operative policy.
Just a thought.
okay. Well, we'll see what it looks like next Tuesday.
Okay.
Thank you, Ben.